Welcome back, friends. So, after understanding the basic concept of IBC and the overall framework of IBC, let us move ahead and understand what is the process for filing a case at NCLT for taking a company to the insolvency process. Friends, very important to understand IBC is a reality for all the corporates. They need to understand that if they are not performing well and if they are not paying the debt, probably the IBC will take away the ownership from one to another. इसलिए reality is very important. रख लो आईना हजार तसल्ली के लिए, पर सच के लिए तो आंखें मिलाने ही पड़ती है. And that is what we need to understand. So, and very important, friends, and let me tell you, people have to get into the habit of this IBC process, and they need to understand that IBC is part of the whole business domain, and it's a cycle, and any company can fall into this particular IBC. और ये नहीं कहना कि बाद में हमें समझ नहीं आया और we not understand या बाद में वक्त नहीं है. जैसे इश्क में होता है आदत बेपनाह मोहब्बत की डालकर, अब वो कहते हैं क्या करो वक्त नहीं है. ऐसा नहीं हो सकता इसमें. You have to understand, you have to take it as an integral part of your plan. Okay, so let us move ahead and understand the process. So the case of IRP application can be initiated by, as we have understood in our previous lecture, by the FC, that is the financial creditor, the operational creditor, the OC, and the company itself. That is also a major provision under the fact that the company wants to take itself under the insolvency process, it can do so. So that flexibility is also open to the company themselves. So first, let us understand the role of the financial creditor. Under what circumstances the financial creditor can take the corporate debtor, that is the CD, to the CRP process, and what are the formalities which the financial creditor has to fulfill at the NCLT. So the section 7, that is a major section, and if you observe that in all the cases which have been admitted, I think section 7 comprises majorly from the banking angle, and in terms of the number of volume of the transaction of the default, I think section 7 has the major share. The financial creditor can either alone or jointly with others. That is very important, where we all understand that in case of a borrower takes a loan from multiple banks also. So financial creditor can file on its own, or they can club together and then jointly with others, they can file an application before NCLT for initiating the insolvency resolution process when the default has occurred. Remember the word default. That is the important word here, which we have to understand that what is a default, and a lot of cases have been deliberated, and I think the conclusion has been very clearly drawn, and also the IBC code clearly defines what is the default. So default includes the default in respect of financial debt owed not only to the applicant financial creditor but to any other financial creditor. So if a company has made a default to any other financial creditor, and maybe to me it has not done any default, but then because the section says that the default includes the default for any financial debt. So a financial debt, so the two words which you have to understand is the default and financial debt. Financial debt means a debt along with interest, if any, which is disbursed along against the consideration and include money borrowed against payment of interest, that is purely the loan which the bank gives us. Any amount raised by the acceptance under any acceptance credit facility or its dematerialized equivalent. Basically, it means you have raised any credit facility CC or purely in the DMAT form. That is similar to the electronic form. So that is also taken into consideration. Any amount raised pursuant to any note purchase facility. So the banking people give various other facilities like the note purchase. So in that case also it can take the company into the IRP process. Then in the case of issue of bonds, notes, debentures, loans, stock, or any other similar instrument, when the company raises funds through issue of such kind of fixed income instruments against the default of those fixed income instrument repayment, the company can be taken to the IRP process. Then the amount of any liability in respect of any lease or hire purchase contract. So let's say if the company has taken an asset on lease or hire purchase, and which is deemed as a finance or capital lease under the Indian accounting standards, which is issued by the ICI. So if that is treated as a lease, then the company can again be pushed to the NCLT. And when the receivables sold or discounted other than any receivables sold on non-recourse basis. So there are two criteria, recourse and non-recourse, and that is basically concept of factoring. So what simply means here that when the bank or the lender has discounted their bills on a non-recourse basis, then they can take the company to NCLT. And if the company has entered into any derivative transaction to protect against the benefit from fluctuation of any rate or price, basically it happens against the fluctuation of foreign currency or any commodity. For that, they have entered into any derivative transaction, and then they have made a default probably against that particular transaction also. The company could be pushed to the NCLT domain. So these are the points where the financial debt comprises of these are the areas. So very important, it's got a wide coverage. Not only purely means that the company has taken on a loan, and in the case of loan only, the company could be taken to the NCLT. Then the other guarantee aspect is also covered, where the any counter indemnity obligation in respect of a guarantee, indemnity, bond, document, TLC, or any other instrument issued by the bank or financial institution, or any amount of liability with respect to any guarantee or indemnity for any of the items which are listed on from A to X, right? So basically, it means where guarantee has been given, and in case of guarantees invoked, and if there's a default in paying that invocation of the guarantee, probably again that falls under the purview of a financial debt. So as we know now understand that it has got a very broad coverage, and every aspect of the financing world has been taken into consideration for the default which can happen in the financial market. Okay, so we have understood two words. There should be a default. Default means they are not able to repay of any of the financial debt which are listed down here. But then what next? Okay, so next is obviously they have to approach the NCLT and file the documents. So what are the documents which are required to be filed at NCLT? I think very important here to be noted, friends, the documentation, as we all know, that is the most important angle when it comes to legal cases. And normally what happens, cases are lost or won only on the basis of documents. And normally what we have seen that documents are not kept properly. So it is very essential to be understood here that yes, today that we should preserve all the documents in the right place, the right way, the right manner, in the right legal deliberation, the legal language. And normally people do procrastinate this particular habit of keeping the documents in a particular way. And that is why people lose case in the court. So very essential, friends. I think we need to disseminate this information, tell our clients, prospective clients, that do it now, today. Otherwise, procrastination will always lead to a problem. Because we all understand that मुश्किल काम उन आसान कामों का ढेर है जो हमने सही वक्त पे नहीं किया, right? So please note it here that documentation are very essential. So under section, the financial creditor can make an application in form number 6 along with the following document, which will prove the evidence of default, where there's a record of default. So there may be the account ledger, which will show the party has not paid the amount. Evidence of default along with the supporting documents that, I have given a loan, sanction letter of the bank, and along with that sanction letter, all the terms and agreement. Then other records which are essential to prove that there is a default. Then whatever communication which has been exchanged between the parties regarding the payment part, so maybe that will be again submitted. Then a statement of account showing the financial debt payment by the corporate debtor, that this amount was given to this party, and that can be certified by a professional. Then whatever legal notices have been sent in due course when the default had occurred by the financial creditor, and any reply which has been received from the CD. Finally, certain permission, which consists of the board resolution authorizing the person who will sign the petition. And then obviously there has to be some money involved, because we will be taking time of the legal people and the department of Ministry of Corporate Affairs, and along with the respective judges, they'll spare some time on understanding the application. So a minimum amount has to be paid. And then the supporting ancillary documents of memorandum, article of corporate debtor, consent of the IRB, very important element, that The financial creditor would like to appoint an insolvency resolution professional who would execute the whole process. Therefore, they need to file a consent of the IRP along with the document, which is required in a designated form. So that consent has to be given by the IRP friend. And then there has to be an application for interim stay if required. So, if you legally understand what the section says, it does not postulate service of notice upon the corporate debtor. It means what? When I'm filing and going and filing an application to the NCLT, it is not required that I have to serve a notice before filing the application to NCLT that please repay the debt. Probably it is not there. So there's no such condition required. But maybe we on the safer side, the financial creditor may send a notice, but then it is not at all required, right? So serve a notice upon the TD. Clearly mentioning that this amount is due from you. So probably this is a big leverage which is given to the financial creditor that in the case of default, they can directly file a case without telling the corporate debtor of the same. So that was section 7. That is the basic premise of section 7. Now let us move ahead and understand section 8, which relates to operational creditor. As we all know, there are two types of creditor, the FC and the OC. So we come to the OC. The differentiation is very clear. Financial creditor with respect to financial debt, and operational creditor with respect to supply of services or material to a particular corporate debtor. So section 8.1, which says that if there is a default in payment of a debt, the creditor will have to give a 10 days demand notice. So here there is a requirement. Understand the difference between section 7 and section 8. Now section 8 is not saying that they can go and file an application. Section 8 is saying that in case of default, the operational creditor has to give a demand notice. Demand notice purely means that please pay my amount, right? That is the designated form number 3. That form has to be sent to the corporate creditor along with the copy of invoice demanding the payment of invoice. That please pay me this amount for which I have supplied the material or services against that particular bill. Please pay me the amount, or it can be a combination of lot of bills. So that means it is mandatory that along with notice, copies of invoice must be sent to the operational creditor, the corporate creditor, sorry. Otherwise, the notice shall be held effective and the petition is liable to be dismissed. It may happen, right? And that above provision has been stated in not many case laws, and one of the case laws is listed down here, that the demand notice along with the invoices has to be sent, because that will actually give the confidence to the adjudicators and also approve that yes, this amount has been due. Okay, so what will happen? So if suppose let's say a company sends a demand notice to the corporate creditor, please pay my amount. There may be two situations. That situation can be the corporate creditor may give a reply or may not give a reply. So the response is like that the corporate creditor shall have to point out within a period of 10 days that I'm not paying that amount because there is an existence of dispute, and shall produce the evidence of any suit which is pending or any arbitration proceeding, or alternatively the corporate creditor will produce the proof of payment, and whatever the case may be. If they made the payment, so probably they'll come out and say that I made this payment, and that is why therefore there is no such default, and they need to produce that evidence. So maybe the bank statement or any proof the receipt where it does receive that receipt from the operational creditor that yes, the amount has been received. So either they have to prove the existence of a dispute, or they have to prove that the payment has been made. So that response may come in. And if the response does not come in, that means the operational creditor has the right to go and file a case against the corporate debtor. And that will happen under section 9. Remember, section 8 talks about sending a demand notice. Remember, we have to first send a demand notice, which is not there in section 7, which is basically a pre-requirement for filing an application under section 9 by the operational creditor. So section 9 of the code says that after expiry of 10 days, the operational creditor has got the right to file a case against the corporate debtor where the payment has not been received or any response has not been received by the operational creditor from the corporate debtor. And obviously, when we'll file, the petition has to be accompanied by so many documents. As I said, it is very important to preserve all the documents. So it may consist of invoice showing supply of goods, statement of account showing that the payment has not been received, then the communication between both the parties over a period of time. Consent of IRP may or may not. I mean, this is again a difference between the section 7 application and section 9 application, where it is not required to, the operation creditor is not required to compulsorily submit the consent of IRP. Then there's an affidavit swearing that no notice was given by the corporate creditor relating to a dispute. That means there is no dispute exists, and the corporate debtor has not responded to my notice, and they have not raised any dispute. So this affidavit will be required, and very important. And if there's a dispute, then obviously we cannot go and approach the NCLT. Though if you want to go, we can do that, and then the NCLT will take the case into consideration, and then whatever proceedings will happen, that is subject to all these proof and evidence submitted in due course of the proceeding. And then we have the copy of certificate from the financial institution, that is the bank, maintaining account of the operation creditor, confirming that yes, no payment has been received from this particular corporate debtor over a period of time, and we need to submit a bank statement for, let's say, last 1 year, where the proof will be submitted, yes, that we have not taken, the payment has not been received. So NCLT has dismissed number of petitions where the certificate has not been enclosed from the banker about non-receipt of payment, in respect of which the petition has been filed. So very important, a bank statement has to be submitted. And these points have been again reiterated in not many cases, and one of the cases has been mentioned here, the Smart Time Limited, that the NCLAT has held that filing of certificate from the financial institution is required. That is a must. Right? So remember, please note it that the bank statement has to be submitted. So these are the requirements for filing for documents under Section 9. Along with that, the normal course where we have to submit a board resolution, a fees payment of 2,500, copy of memorandum and article of corporate debtor, and application for insolvency, anything. So, two sections we have covered, Section 7, Section 9. They form the crux, they form the base, they lay their foundation, where we can take the company for the CRP period and for the insolvency, and therefore these are the two major sections across the adjudicating authority domain. We'll see that applications are filed in the Section 7 or 9, and from there the IBC takes off, and once the decision is taken, thereafter the remaining sections come into picture. So friends, Section 7 and 9 are major points, and probably there are so many other factors attached to Section 7 and 9. It's not purely a financial debt, a default, and so on. A lot of disputes have happened under Section 7 and 9, at both levels, and deliberations go on for more than 6 months on the aspect whether there's a default or not, whether the financial debt is there or not, whether there's a limitation of time has been overcrossed or not, limitation of time, where we all understand that, debt can be recognized only for a period of 3 years. Beyond 3 years, we cannot acknowledge, we cannot take any company for recovery if the debt is more than 3 years old. So a lot of disputes happen, and if you observe all the case laws, you'll find that some are in favor of the operational or the financial creditor, some are in favor of the corporate debtor. It all depends upon case to case, but the prime criteria are that there has to be default, there has to be financial debt, and all the requirements of preconditions under Section 9 and Section 7 that has been fulfilled. Then probably the operational and the financial creditor are in the safe zone, and then NCLT will definitely accept the case if you have done all the requirements. So we have started with the process of CRP, friend, where we have understood what is the first step for filing a case in NCLT, that is Section 7 and Section 9. So this completes our first part of chapter number 2. And see, we have not considered the chapter number 1, because chapter number 1 takes into consideration the a lot of definitions, the preliminary part. And even chapter number 2 starts with Section 4, Section 5, and 6. And as we have seen in Section 7, we have referred to certain definitions of default and financial debt. So we need to refer to the definitions at different point of time. That is why I have not covered the definition part, because that will come in due course when we cover each and every section. Some points and words will be mentioned here, and we'll refer those words and the definition of the words as per Section 5. Okay. So here we take a break again, because that is the foundation before we jump into the other complications